Welcome back to our law course. In our previous lecture, we discussed the dynamic relationship between law and social change. Today, we will explore the interactions of law with three fundamental concepts: justice, equality, and human rights. Justice is a complex and multifaceted concept with various interpretations. At its core, justice refers to fairness, equity, and the upholding of moral and ethical principles in legal and social contexts. Legal systems strive to achieve justice through fair processes, impartial decision making, and proportionate outcomes. Different types of justice: distributive justice, concerned with the fair allocation of resources, opportunities, and burdens within society. Procedural justice focuses on the fairness of the processes used to determine legal outcomes, ensuring that all parties have an equal opportunity to present their case and be heard. Retributive justice emphasizes punishment for wrongdoing as a means of restoring balance and deterring future offenses. Restorative justice aims to repair the harm caused by a crime or conflict through reconciliation, mediation, and restitution. Equality is a fundamental principle in many legal systems, enshrined in constitutions and international human rights law. It refers to the equal treatment of individuals under the law, regardless of their race, gender, religion, or other characteristics. Different dimensions of equality. Formal equality focuses on equal treatment under the law and prohibits discrimination based on specific characteristics. Substantive equality recognizes that equal treatment may not always lead to equitable outcomes and seeks to address underlying inequalities through affirmative action or targeted policies. Equality of opportunity aims to ensure that everyone has a fair chance to succeed, regardless of their background or circumstances. Human rights are fundamental rights and freedoms that are inherent to all human beings, regardless of their nationality, race, religion, or other status. These rights are universal, inalienable, and indivisible. International human rights law. The Universal Declaration of Human Rights (UDHR), adopted by the United Nations in 1948, is a landmark document that outlines the fundamental rights and freedoms that all human beings are entitled to. Numerous international treaties and conventions have since been established to protect and promote these rights, including the International Covenant on Social and Political Rights (ICCPR) and the International Covenant on Economic, Social, and Cultural Rights (ICESCR). Challenges and controversies. The pursuit of justice, equality, and human rights is an ongoing challenge. Legal systems often grapple with complex issues such as balancing competing rights. In some cases, the rights of individuals or groups may conflict with each other. Courts and policymakers must weigh these competing interests and find solutions that balance individual liberties with the needs of society. Addressing systemic discrimination. Despite legal protections, discrimination based on race, gender, and other characteristics persists in many societies. Addressing these deep-rooted inequalities requires a multifaceted approach, including legal reforms, education, and social awareness. Ensuring access to justice. Many individuals and communities face barriers to accessing legal services and remedies. Ensuring that everyone has access to justice is crucial for upholding the rule of law and protecting human rights. Law plays a crucial role in promoting justice, equality, and human rights. By establishing fair and equitable legal frameworks, protecting fundamental freedoms, and addressing discrimination and injustice, law can contribute to a more just and equitable society. Understanding the complex relationship between law and these core values is essential for everyone interested in promoting social progress and upholding human dignity.